The Honorable Stephen D.
Please be seated. Good morning, everyone. Welcome to the Topeka docket of the Kansas Court of Appeals. If you're scheduled to be in some other court, now's the time to leave, because we're just taking up our Topeka cases. We have 3 cases set for oral argument this morning, and I see none of them have been allocated extra time, so we'll be observing those time limits. We will take the cases in the order in which the docket has been prepared. It's my honor to be serving on this panel with Judge Kim Schroeder to my right, longtime member of our court, and to Senior Judge Mary Christopher to my left. Counsel, we have read your briefs, and we might have a few questions, so be sure to listen carefully to our questions. I won't give you advice on how to make your arguments, but 15 minutes is not very long. Since we're familiar with the facts, you might want to go directly to your legal arguments, so we can hear and try to understand your argument. One of my tasks as a presiding judge is to be the timekeeper. If you represent the appellant and wish to reserve some time for rebuttal, tell me. Otherwise, each side gets 15 minutes. There is a fancy clock somewhere around here that I never use. I just use my phone here, and if you hear the sound of the ducks, your time has expired. So you'll understand after you hear it one time. All right, first case that we have set is State versus Ogwongi, 124328. And Mr. Scheer, you represent the appellant, and are you requesting rebuttal time?
Minutes, please, Your Honor.
3 minutes, okay.
May it please the court, Eric Ogwongi appears through counsel Casper Shire, Kansas Appellate Defender. Eric has been fighting against a false rape accusation since 2017. More than 7 years later, Eric is still in the middle of his direct appeal from jury trial for a number of reasons: a charging delay of nearly 2 years, a trial not held until May of 2021 at the Douglas County Fairgrounds in response to transcripts and record reconstructions adequate for this appeal. That's all part of the greater fabric of Eric's case, but what we're really here to talk about, of course, is whether or not Eric got a fair trial at the fairgrounds in May of 21. And for a number of reasons, he did not.
Mr. Scheer, you used a term in your brief, bait and switch. The last time I've heard that term used was in a consumer fraud case where a merchant allegedly used bait and switch tactics. I'm not familiar with bait and switch in prosecutions. Enlighten me. What is your theory? What bait and switch happened here?
The fundamental problem, as we see it, Your Honor, is that the defense made motions seeking to exclude particular evidence from trial, evidence with a particular content, specifically Sandra, Eric's wife's initial opinions of the complaining witness's credibility, and also evidence related to therapy that the complaining witness may have participated in. Before trial, the state essentially short-circuited that litigation by saying, this evidence is not appropriate for a case in chief. We don't need to hear these motions because this evidence isn't going to come in.
You had filed a pretrial motion to exclude this evidence.
Yeah,
Correct.
well, as to the credibility evidence, yes. As to the therapy evidence, no, but that didn't happen until 5 days before trial. So there was some litigation about not having the therapist testify, but of course, then the same evidence came in through a different door at trial.
So you reached an agreement, or the defense reached an agreement with the state.
That, yes. And the court recognized that the state was not going to be admitting this evidence in its case in chief. And, you know, as to the credibility evidence, the specific objection was, hey, we received discovery of these text messages where one witness is commenting on the credibility of another witness, and that can't come in. And the Court of Appeals, again, the litigation on whether or not that could come in never really fully happened because the state said, don't worry about it. We will not be admitting this during our state case in chief. And then when we get to trial, the state gets up in opening argument and essentially starts reading the content of those text messages into their opening statement as evidence that the jury is going to hear. And the defense objects and says, hey, we litigated this pre-trial. We had an agreement, Your Honor. And the state turns around and says, well, we're not admitting the text messages. We're admitting the in-person conversation. But the in-person conversation and the text messages were the same. The content was identical. The only difference is precisely what format it comes in. But this was never about, you know, whether this is admissible hearsay. This was always about the content of those messages.
So you think the defense was ambushed by the state?
Yes. Yes, not only with that, but also with the therapy evidence.
And this was crucial because the declarant was the wife of the defendant.
And the college friend and you know, best friend, for lack of a better word, of the complaining witness up until, you know, all of this happened. So as to the credibility evidence, that's why this is so important to this case, because this is a person who the jurors are going to look to solve, you know, a credibility dispute between Eric and his accuser.
So what relief are you asking from us?
A new trial, Your Honor. And I'd like to emphasize that this is not the only way in which Eric was denied a fair trial. There was a Doyle violation at trial. And of course, when I'm talking about a Doyle violation, I'm talking about the state asking questions of law enforcement witnesses where those, you know, the officer responds, I didn't talk to Eric because he invoked his right to remain silent. Because he wanted to talk to an attorney. The district court, the district court actually found a Doyle violation in this case. They didn't find it reversible, but they did find a Doyle violation. And we see that at the sentencing hearing where the court went as far as saying that the state asked an improper question. We feel that is reversible on its own, but even if it's not, it goes in.
Pardon me?
That doesn't sound like the Ducks, Your Honor, so I'm just going to keep talking.
No, it's not the Ducks.
Even if that's not reversible on its own, it goes into the bucket of cumulative error at the end of the case. And there were a number of other places where the state can be seen, you know, if not crossing the line, and certainly we feel that they were, but if not crossing the line, certainly pushing right up against it. The puzzle pieces argument in both opening and closing, which our Supreme Court says is not an appropriate argument.
Well, the state rather glibly replies to that as it scuffed the line. What's your response to that?
My response to that is, you know, even if it is scuffing the line and even if it doesn't quite go over, that's a theme in this trial. I think the state knew that they needed to push hard for a conviction in this case. They didn't have physical evidence that corroborated that corroborated the claim, and they pushed too hard. They pushed over the line.
I was going to ask you about a comment that the prosecutor made about the evidence from the examination, the forensic examination of the victim.
Yes.
Tell me about that.
The comment there that troubles me the most is, and I'm paraphrasing a little bit here because I don't have the exact quote in front of me, but the state says something to the effect of, because of the sure nature of that examination, a consensual encounter is ruled out. And that's simply not the case. A sane examination cannot reveal whether sex was consensual or not. And that is not what a sane examination is there to do. In fact, the witness, the sane nurse who testified, said, yes, there were some, I found some abrasions, but those abrasions could be from either consensual sex or non-consensual sex. There's no way to look at that and tell. So for the state to stand up and say, the sure nature of this examination rules out a consensual encounter, that's misleading to the jury, Your Honor.
Is that harmless?
No, it's not harmless, because in a state that was in a case that was lacking physical evidence, and juries do want to see physical evidence to back up very serious claims, it gave the illusion of physical evidence that wasn't really there.
Now, to make it clear here, there is no contest that there was sexual intercourse.
No, there's not. That was never the question in this case. The question in this case was always consent.
You still have 3.5 minutes, counsel.
I think I have touched on all the major topics that I wanted to get to in my initial time. If this court has more questions, I'd be happy to take them. Otherwise, I'll save my remaining thoughts for rebuttal.
Anything further? No. Okay, thank you.
Thank you, Your Honor.
We will never penalize an attorney for taking less time than is said. Counsel, your appearance, please.
Yes, may it please the court, Your Honors, the state appears by Douglas County Assistant District Attorney Brian Dyer.
Are you on the brief, counsel?
I'm not, Judge. I did enter my appearance. Mr. Simpson is out on leave at the moment, so I will be arguing this on his behalf.
And is it your last name, please?
Dyer, D-E-I-T-E-R.
D-E-I.
T-E-R.
Okay. All right. Read, counsel.
Thank you. So, as the court touched on, well, as the court was primarily interested in the bait and switch.
Tell me about that. It's a pretty abusive declaration he's making about your office. That virtually unethical.
I don't disagree. It is a pretty serious allegation. That being said, there is no bait and switch. When we agree to one thing, we do a different thing. Essentially, the state agreed not to have the victim's therapist testify at trial. That being said, the state never agreed not to ask the victim herself about her mental health or her therapy after the fact. On that same note, the state also agreed to exclude some text messages between the victim and Sandra Yoder, but the state never agreed that no conversation between the two parties would come in. So the state did present evidence of an in-person conversation between the two, but it didn't admit any sort of text messages into evidence.
So are you telling me then there was a fundamental misunderstanding between the defense and the state about what the subject of your agreement?
I would say so, yes.
The defendant thought that it was the subjects that you weren't going to touch on, and the state thought you were not going to offer particular witnesses.
Yes, effectively, the state agreed to one thing and it did a different thing.
And you're,
Can't call that a bait and switch.
okay. What did you think you agreed to?
That essentially we wouldn't endorse the therapist as a witness and we wouldn't call that therapist at trial.
And you did not.
Correct. And the state never agreed to not ask the victim about her therapy efforts. In fact, that was never even mentioned in front of the district court, as far as I can tell. So
Wasn't there a request by the defense to disclose if she'd been to a therapist and your office said she had not?
correct, at that point in time, it was not known to us that she had been in therapy. Once it became known to a subsequent attorney, the attorney who tried this case, that was disclosed to defense, and all the records that we were able to get by that point were turned over to defense, and that was prior to trial.
Was that 4 or 5 days prior to trial or months before trial?
I believe it was a couple weeks. But effectively, all of this was known. The state's mention of therapy at all was extremely fleeting. Essentially, it was just, do you suffer any sort of mental health consequences as a result of this incident? Have you been going to therapy? Were you diagnosed? And that's effectively all that was asked at trial. And given that, the state didn't really explore in depth into that, but the state effectively agreed to one thing and it upheld that agreement. If defense wanted additional things excluded, the reality is they should have been more specific as to what they wanted excluded, because the agreement encompassed just the therapist and the therapy records, and it encompassed just the text messages. It did not encompass any evidence of mental health or therapy by the victim, and it did not encompass any sort of in-person conversations between the victim and Miss Yoder.
Well, counsel said that the text messages were read basically verbatim in opening statement. Is that true?
I don't believe they were. I believe that a large part of the substance of the text messages were also discussed in person. That was my understanding based on the record, but I don't believe the text messages themselves were read. So going on to the prosecutorial error component. So essentially, Mr. Agwangi's alleging 3 instances of prosecutorial discretion, the first being that Doyle violation. Essentially, that was, well, first off, Doyle only applies when a subject has received a Miranda warning from the officers. In this case, Mr. Agwangi made, well, the instance where officers testified that he made no comment to him, that was when his house was being searched under a warrant. Effectively, he was not arrested and charged until, I believe, a year later after that. He was not read Miranda at that point. Essentially, all this officer testified was, yeah, he didn't say anything to us because he wanted to talk to an attorney first.
Well, the district court found a Doyle violation, didn't it?
I
That
believe
it was an improper question. Are you arguing then that's just simply harmless?
Yes, Judge. That is one aspect of it. Well, the other end of it is that they also kind of opened the door to it. Effectively, defense's entire strategy during trial, throughout trial, was to push a narrative that the police did nothing except for talk to the victim and execute a search warrant on Mr. Agwangi's home.
That's essentially what happened, wasn't it?
Correct. But they were also pointing fingers at law enforcement saying, oh, they didn't investigate any further than that. They didn't talk to my client. They didn't talk to Miss Yoder. They didn't talk to whoever else. But officers did try. And I think that kind of rebuts that narrative that officers did nothing except for talk to these 2 people and execute a warrant. Because officers did try to get Mr. Agwangi's side of the story. He just didn't speak to them. And at that point, when that's their primary argument at trial, I think that's fair rebuttal. Even beyond that, though, it is harmless under the entire context of this case. Essentially, essentially, the court immediately sustained the defense's objection on this question. Without any comment by the state in response, directed that no further questioning or argument with respect to that silence.
You think that was prophylactic then, the judge's comment?
I believe so, Judge. Plus, there was also an advisory to disregard that comment to the jury, and I think under those circumstances, it does become harmless.
My question to you centers more on the jigsaw puzzle.
Yes.
How many times does an appellate court have to say that prosecutors should not use that analogy because it shifts the burden and lessens the burden in many? When is it going to be acceptable? Are you arguing that that's what was done here was acceptable?
I am, Judge, and that's why the state's argument is that it scuffed a line rather than crossed it. I don't disagree with the court that the puzzle piece analogy as typically used is not appropriate, but I think this instance was essentially the only common theme is the use of a puzzle.
Just because that's the only trick that you have in your rhetorical bag doesn't mean that it's acceptable, counsel. I mean, when the Supreme Court says you aren't supposed to do it, you're not supposed to do it. I mean, that's the long and the short of it.
I don't disagree. Typically when this happens though, well, the use of the word puzzle shouldn't necessarily result in error just instantaneously.
If you keep on doing it, you're going to continue to find error and you're going to have cases reversed.
I don't disagree, and I think it does come close, but in this instance, essentially, when the court has previously found this sort of analogy improper and erroneous, it's essentially when the prosecutor tells the jury, hey, we're going to be putting together a puzzle. There may be some pieces missing, but you can still see the bigger picture. Here, the puzzle was used as we're going to give you all of the pieces, and it's up to you to put it together to create the bigger picture. And the state believes that bigger picture is going to prove rape. This is different because we're not saying we're not meeting every element. We're not saying that there's going to be things omitted that you need to overlook. We're saying that it's up to you to paint this picture of what happened based on the evidence that we're giving you, based on these puzzle pieces that we're providing. And that's the distinction between the two. So I think in this instance, this puzzle piecing analogy did obviously got close to error, and I think that's the court's concern, but I don't think it crossed that line. But
can this be a harmless error?
I think so, Your Honor. Well, first I do want to point out that essentially defense counsel during trial agreed that this state was a puzzle. But essentially this analogy is basically telling the jury that not every corner of the painting needs to have paint on it. So basically it may not have been the most advisable analogy, but it's still clear that they're proper. And even beyond that, it didn't make Mr. Agwangi's otherwise fair trial unfair. Both the parties' other comments and the court's instructions, again, reinforced that the jury was to decide the case under a reasonable doubt standard that no party nor the court could even define to them. Defense counsel's opening statement, again, expressly endorsed and borrowed the puzzle piece analogy, telling the jury that they agree with the state. This case is a puzzle. And even an analogy-free trial.
Well, it's one thing for the defendant to do it. It's entirely something else for the party with the burden to say it. And if you say it, and if you continue to say it, we're going to continue to find error because the Supreme Court has said, don't use it. And if you continue to use it, we're going to start reversing cases based upon its use until you get the idea that you shouldn't use it.
And again, Judge, I think the only common theme between the disapproved puzzle piecing analogies is essentially the word puzzle. I think this is more akin to I think it was State v. Lowry that was in the state's brief, but State v. Jackson, not every little corner of the painting has to have paint on it. And that's an approved analogy by State v. Jackson. So effectively, we're saying we're going to give them the tools to make this picture, but it's up to them to put it together. rather than overlook these missing pieces.
And it's tantamount to saying, we may not present everything that we need to prove beyond a reasonable doubt, but you can fill it in. That's what it's tantamount to saying. And if you find that isn't burden shifting, then you need to reexamine what your responsibility is as prosecutor.
And I would
The
just,
burden is not upon the defendant to prove anything. The burden is upon you beyond a reasonable doubt. And it's not left for the jury to fill in the puzzle. And that's the problem.
And-
But you need to go on to something else because your time is about, you got about 2 minutes left and you've got other things to talk about.
yes, so I also want to briefly touch on the other prosecutorial error arguments. Primarily the sane exam reports. That did not shift the burden nor misstate any sort of evidence. Defense, well, Mr. Schreier got up here and said effectively that what in this, well, he painted the state's characterization of this as this isn't consistent with consensual sex. But that's not what was stated at trial. The state said, what in this report, let's see, what in this report in any way indicates that this was consensual sex? It doesn't indicate either way. All it indicates is that sex happened. And that was the point of that statement. The second comment did more so, and that's just stating by their very nature, these examinations and reports are not generated resulting from a consensual encounter. And that's true. That's in their very name. That's what SANE exam stands for, sexual assault nurse examination. People who had consensual sex don't undergo this invasive procedure. And that was the point. And that was the message that the state was getting across. And
So I think what you're saying is the state is saying just because they have an examination by a nurse, that means they were sexually assaulted.
no,
Isn't that what
essentially
you're
what the
arguing?
state was saying, it doesn't indicate either way, but it indicates a motive for the person to go get it. The person's motive
That's
is,
not what the words that was used by the prosecutor here.
no, the exact words is by their very nature, these examinations and reports are not generated resulting from a consensual encounter. And that's true. Why would someone who had consensual sex go get a sexual assault examination? And that's the question for the jury. And it essentially boils down to, it's up to you to decide whether this was consensual based on this victim's testimony. But here's the thing.
It doesn't sound like that. That's a question at all. It's a statement made by the prosecutor that says, look, she had this exam and you don't get these exams unless you were sexually assaulted. Isn't that what he's saying? And that's why it's objectionable?
I don't disagree with that characterization. I don't think it's necessarily the most accurate, but I think either way.
Those are the days. No, you go ahead and finish that, counsel.
Well, I think either way, it's harmless for the number of reasons pointed out in the brief. Counsel statements are not evidence, and that's always my favorite jury instruction to point out at trial. And thank you, your honors. Wish I had more time, but
All right, thank you, counsel. Mr. Sheriff, you got your 3 minutes.
Thank you, Your Honor. I'd like to close with just a couple of quick things. First, there were questions about the therapy evidence and when all of that came up. It was a hearing held 5 days before trial. That was where defense said, we never got these records. We still don't have these records. I think we need to talk about discovery sanctions. And the state said, we're not calling the therapist. Again, I don't know how Eric is supposed to take that besides this therapy evidence isn't coming on. Equally, when talking about El Nikki, I'd like to read the court's ruling, at the end of that conversation, after the state has said, we're not going to put on that evidence. That's totally proper. So show that the motion is withdrawn as moot, given the state's concession that this is not proper evidence for their case in chief. Not that it's improper hearsay, not that it shouldn't come in this format, but that it's improper evidence. And I encourage the state to look at page 17 and 18 of my brief, which lays out the text messages versus how the state presented them in their opening argument. I think that speaks for itself. Finally, we've had some conversation today about whether this error or that error or a third error is reversible on its own? My answer to all of those questions is yes, they are reversible. But above and beyond that, they came together to deny Eric a fair trial. And that's what cumulative error is all about. The cumulative effect of these errors, separate and apart and together, denied Eric the fair trial that the Constitution promises him. And we do ask this court to reverse his sole conviction so that he gets that fair trial.
Anything? Thank you, counsel.
Thank you, Your Honor.
Take this case under advisement and issue a written opinion in due course. Thank you. You may withdraw. Next case is 126246. Luis A. Ramirez. Counsel, please enter his appearance.
Our state appears by Assistant District Attorney for Douglas County, Brian Dieter, on behalf of John Simpson, who briefed this case.
All right, thank you, counsel. And are you wanting rebuttal time?
I did ask for, let's go with 5 minutes.
5 minutes?
Yes.
Okay.
Well,
You got it.
let's make that 4, actually. So,
4?
yeah.
All right.
You got double duty today.
Unfortunately, it's a first for me. Switching gears.
All right, proceed, counsel.
Thank you, Judge. So this case this is a single issue appeal filed by the state, and it concerns probable cause and proportionality under Kansas's immunity statutes. Primarily, it's a case that was dismissed after an immunity hearing, which in the state's opinion, probable cause was established that Luis Nava Ramirez committed an act of violence against his then girlfriend, Sierra Cheshire, which was not legitimately carried out as an act of self-defense. Effectively, the state's arguments today are that Mr. Ramirez struck Cheshire without genuinely believing that it was necessary for his own defense, or in other words, that he didn't subjectively believe that he needed to physically defend himself against her.
Tell me, the record seems to reflect that she was the initial aggressor and she admitted that to the officers.
So it depends on the construction of what an initial aggressor is. And
Well, I mean,
effectively,
she pushed him around the house and slapped him multiple times. Is
yes.
that what the evidence reflects that she admitted to?
So yes, and that's what the district court found as well. That being said, it omits extremely important context from that. Prior to her, I believe, slapping Mr. Ramirez had punched a mirror in Miss Cheshire's residence repeatedly, to the extent that the mirror is broken, his hand's bleeding. At some point, Miss Cheshire tries to escape by locking herself in the bathroom. His response to that was punching a hole through the wall. Eventually, she comes out, slaps him, tells him to get out. He says no, and punches her back in the face. And that's essentially the proportionality argument. Is all of this proportional? And effectively, it boils down to what I like to consider dueling self-defense claims. Well, dueling immunity claims, I guess. It's my opinion, based on this evidence, that Miss Cheshire did have a essentially valid claim to immunity for slapping Mr. Ramirez. He had essentially put her in fear and made her feel physically threatened to the point where she had to hide in her bathroom. He then punches through the wall, and only then does it get physical between the two. But essentially, she slaps him, and he closed-fisted punches her in the face, and then they continue fighting around the house. And that's the context that was missing well, that was not considered by the district court in finding that she was the initial aggressor.
In other words, you're arguing that this was a violent laden situation. It may not have had physical contact initially, but there's clearly violence emanating from the start.
Correct. And I think that's kind of a common theme in cases like this involving domestic violence, is that it doesn't always start out physically violent. A lot of times there's just one party feels threatened by the actions of another. And I think under the circumstances, when you're locking yourself in a bathroom to try and get away from your significant other and they punch a hole through the wall, I think that's understandable from an objective viewpoint to feel threatened at that point. So yes, Ms. Cheshire did slap Mr. Ramirez first, but that was after all of this had already occurred. And then we get to the proportionality part where, is it proportional for this man to punch his girlfriend in the face after she slaps him and says,
Well, what's the
"Get out."
definition of reasonable?
Well,
You have the right to meet force with reasonable force, don't you?
yes, and effectively, that's, I believe the exact terms are an ordinarily prudent person, but it's what's reasonable both subjectively from the individual who used the force from their viewpoint, and it's also objective from the viewpoint of an objectively reasonable person in similar circumstances.
So you're saying if I slap you, you've got a right to punch me?
No, I'm saying the opposite.
Yeah, you're saying you slap me, I can slap you back, but you can't pull a gun and shoot me.
Exactly. And I think,
I'm in proportion,
yes,
out of proportion.
yes, and I think that's the kind of the point is proportional conduct essentially warrants a proportional response, but that's not what happened here. I think that's what Ms. Cheshire,
You're trying to draw a distinction between a slap and a fist?
yes, essentially,
Both involve contact, right?
yeah, one causes more harm, and that's something that we saw from this hearing is that Ms. Cheshire had a swollen lip. Mr. Ramirez's only injuries were self-caused effectively from when he punched the mirror and cut his hand on the glass. And that's kind of the point, is it's not proportional when only one party gets injured. And I think that's kind of what it boils down to on an objective basis.
Where's that written in the statute?
It's not. And effectively, that's just our case law on immunity. It has to be both subjectively reasonable from the viewpoint of the individual using the force, and objectively from the viewpoint of an objectively.
And once the defendant struck her, the situation de-escalated, is that correct?
No. My understanding is that
He left because she was no longer restricting him from leaving. And she called the cops.
so,
I mean, that's my recollection of reading the record. And he was outside when the officers arrived.
yes. So effectively, things did cool off after this, after she had called the police as well. And my recollection is that she called the police and stated that she did that because she wanted someone else to tell them that they needed to separate. Or effectively to tell the defendant that they needed to separate. Because she had asked him to leave prior to this physical altercation, he effectively just said no, because it is her house or her home. But yeah,
Okay, I'm interested in your briefing. You've raised 3 issues on appeal in your briefing as to why immunity doesn't apply.
yes,
The first one is Lewis did not subjectively have a genuine belief he needed to use force in self-defense. I see that. Explain to me why that's not a new issue on appeal.
explain why it's not a new issue.
Right, I don't see that you addressed it before the district court.
Yes, Judge. Well, from the state's view that this was addressed, because that's effectively the entire purpose of the hearing, is to address all prongs of immunity. That includes the subjective belief of the defendant, the objective, essentially the objective standard of what was reasonable as well.
But you raised that in your second contention that Lewis used more force than reasonably necessary.
Yes, and that's just essentially the legal framework that self-defense immunity claims are assessed under is the subjectively reasonable prong, the objectively reasonable prong, because it has to be both for immunity to stick.
All right, and your third issue you raise is Lewis is not entitled to self-defense immunity as an initial aggressor or a mutual combatant. Where was that raised below?
Yes. And again, that's just part of the statutory theme. Essentially, there's a list of presumptions. I believe it's KSA 215226 off the top of my head. But regardless, there's a list of statutory presumptions, one of which is that an initial aggressor is not entitled to self-defense, and that was essentially the scheme that this was addressed under. But I think even regardless of that, whether or not the court finds it preserved on that basis, the court can still review the issue just on the grounds that it's necessary to serve the ends of justice. And this wouldn't be a novel case where the court does that. Panels of this court have done that previously, and there's a number of cases cited to in the state's brief on
But
that.
if it wasn't raised below, it's our discretion to ignore it here.
That's correct. It is the court's discretion still. And I'm not disagreeing with that.
All right, and so what are spicy nuggets?
That's a great question. So
I mean, it's mentioned multiple times in the record, but nobody defines it.
yeah, so effectively, that was how Mr. Ramirez defined his punches against Miss Cheshire.
The record that I reflect is a punch, not punches. That's a big distinction, isn't it?
Yes, but in this instance, Mr. Ramirez effectively said, I gave her a couple of spicy chicken nuggets, which he essentially was referencing punching. So whether one punch or two, either way, Mr. Ramirez says that there was multiple, but effectively, the state's point in bringing that into the brief is that Mr. Ramirez he seemed kind of boastful after the fact that, yeah, I just gave her a couple of spicy chicken nuggets. You just punched her in the face. And that's kind of the concern as far as the subjective mindset prong of this analysis goes, is that these kind of jokes after the fact, did Mr. Ramirez legitimately have a subjective belief that he needed to physically defend himself against Miss Cheshire? I think under those facts, no. And I think given that we're left to essentially make inferences from other evidence, because Mr. Ramirez did not testify at this self-defense immunity hearing, so effectively we have to draw inferences as to his subjective intent. And I think that carries a lot of weight as far as that goes.
So it's interesting to me that she admitted that she was the initial aggressor to the officers, and they arrested the man. Does Douglas County have a policy on domestic violence that they arrest the man and leave the woman alone?
You know, I can't speak to the policy, but I don't believe so. But effectively, I think the circumstances showed that this was warranted in this situation because, yeah, she said she made physical contact with him first, but that's not the whole picture, and that's not the whole story. And it looks like I'm out of time, but
I'll let you finish your thought.
I don't think that's the whole story. And that's the point, is that we can't just take a narrow view of the evidence and then form an opinion on that. We have to consider it in the totality of its context and circumstances. And I think that's what the district court erred on.
Thank you, counsel.
Thank you.
Your appearance?
May it please the court, my name is Madeline Calcagno, and I, along with my co-counsel, Samuel Allison Natale, represent Mr. Luis Nava Ramirez.
Have you made an entry of appearance?
Yes, Your Honor.
Could you spell your last name for me?
Calcagno.
Thank you. You may proceed.
Your Honors, this court must not accept the state's invitation to reweigh the evidence and come to the opposite credibility determination than the district court. Today, there's been a lot of talk of proportionality and how that relates to the factual implications from what happened below. The standard here we're looking at is not whether it was proportional, The requirement was that Mr. Luis Nava Ramirez acted with no greater force than was necessary, and that is based on his subjective belief at the time of the incident. Here, proportionality, misdemeanor force was what met with misdemeanor force. Ms. Cheshire chased him, walked around the apartment, followed him around the apartment.
It was
pushed
her
him.
apartment.
Correct, Your Honor. Pushed him several times, slapped him several times before he met her misdemeanor force with the misdemeanor force of throwing a punch. This is allowed under the Kansas Self-Defense Immunity Statute. He met a similar type of force with a similar type of force. Earlier, there's discussion about his use of the phrase spicy chicken nuggets. I believe this phrase must be used in its entire context because it's not something all of us use every day. This was a statement colloquially made to a friend where he said, "She came at me, so I threw her a couple of spicy chicken nuggets." I agree with Mr. Dieter that this term spicy chicken nuggets means a punch. The important context here is that he said, "She came at me." In all of Mr. Ramirez's statements in the evidence about what happened, he repeatedly asserts that Miss Cheshire was the one to come at him first, and he only responded to her use of force with force.
I think we have to be careful here, because there could be some humor that is unintended because of his colloquial use of those terms. But it's a very serious subject. Domestic violence is not to be trifled with. I mean, it's a very serious subject. And so his subjective feeling that he needed to punch her in the face is what we're dealing with, no matter what terms that he used. Correct?
That is correct, Your Honor. And Mr. Ramirez made several other statements to officers that were admitted in full in the record in this case that showed his subjective belief was to respond in self-defense, including she was hitting at me first. I don't want to press charges. She kept attacking me, so I came at her back. That can be seen in section 4 of the record at 334 to 348. He was the one who was telling the officers that he didn't want to press charges. This shows.
He really punched through the wall?
Your Honor, this conflict happened throughout the evening. Earlier in the evening, they had been arguing, and Mr. Ramirez did punch Amir in a wall. However, that does not render Mr. Ramirez the initial aggressor here. These were discrete instances separated by time. And
How much time were you talking about here?
I believe
Hours or minutes?
it was all within an evening, and it does state in the record, I'm not sure off the top of my head, but I believe it was an hour at least, Your Honor. She did go into the bathroom, and then after she came out of the bathroom, the district court had several factual findings that demonstrate that she at that point wanted to keep talking with Mr. Luis to work the situation out. And after that is when she began following him around the apartment, pushing, slapping. So that second instance where she was the one who threw the first slap and pushes was separated by time and was a new argument.
Is the state asking us to reweigh the evidence?
I believe so, Your Honor. Here, the state is asking you to read unproven meaning into Mr. Ramirez's statements to try to demonstrate that there was not a subjective belief. However, what this court must do is determine whether the factual findings below were supported by substantial competent evidence, which we believe they were. There are several findings on the record that support the facts that Sierra was the initial aggressor here, including that she didn't want Luis to leave. She pursued him around the room. She got in his face first. Sierra made the first instance of physical contact, which was admitted on several occasions, and that she shoved and slapped Luis repeatedly. These are the factual findings, among others, that the basis was found for his for the immunity finding. There are factual findings to support both that he had the subjective and honest belief that he had to respond with force, whether he later regretted that force or the terms he used to describe it. He believed at the time that he had to respond with force, and there are factual findings to support that objectively it was necessary for him to respond with force.
Is it your argument that we should not be concerned with proportionality? In other words, repaying a slap with a punch?
Essentially so, Your Honor.
Why?
The statute separately contemplates, the self-defense immunity statute separately contemplates when non-deadly force is met with deadly force. That's not the issue here. Here, we're looking at whether no greater force was used than necessary, which is the standard than is reasonably necessary to resist the attack, which is the standard under State versus Marks, 226 can
But the
704.
cases speak of proportionality, don't they?
Yes, and it is my argument that a slap and the punch here, as I mentioned before, both are means of non-deadly force, both are misdemeanor force. And Mr. Nava Ramirez even suffered several slaps and pushes before he responded with a punch, then withdrew, left for the evening, and as Your Honor pointed out, waited outside. So the evidence demonstrated that he left as soon as he could. He removed himself from the situation as soon as he had the chance.
Well, of course, he could have left after she went into the bathroom.
Your Honor, at that point, both parties were still wanting to talk things out. And I think as many people can understand in domestic situations, when there are arguments, there is often a desire to resolve things. And while we may regret not leaving earlier in the evening or how we made certain decisions, that does not mean that he's not statutorily protected from self-defense immunity here, because the only requirements were that he subjectively believed that his use of force was necessary under the circumstances, and objectively his use of force was necessary under the circumstances, which the facts as found, as they were supported by substantial competent evidence, do support.
Earlier, you mentioned that a spicy nugget referenced a punch.
Yes.
Is that your speculation, or do you know that for a fact?
Your
The
Honor,
record's unclear.
yes, that is, I don't like the word speculation, but based on the force that we know was used, I believe that the spicy chicken nugget would have to be in reference to the punch, given that that was the force.
You haven't talked to your client.
Your Honor, as far as I know, that is what he was referring to. I was not counsel at this level, but that has been our office's understanding of the use of the term spicy chicken nugget.
You haven't communicated with the clients, what you're telling me.
I personally have not, no, Your Honor.
So it just leads us to speculate as to whether you're right.
Your Honor, I believe that it doesn't leave us to speculate about whether we're right. I believe it requires us to look at the facts in the record as they are, which show that she pushed and slapped, and he responded with a punch. And that was the use of force that we are here today over. And that punch is what we are determining is subjectively and objectively reasonable. And based on the factual findings as they are, those are supported by substantial competent evidence, and we believe that this court need not speculate or reweigh those facts, because as they were found, Mr. Nava Ramirez is entitled to self-defense immunity under KSA 52-2131. Additionally, Your Honor, there's some mention before about whether this is even reviewable. You spoke with the state about that, and we do believe that these new arguments that the state has raised are not reviewable because they were not mentioned below. Generally, this court does not address even constitutional issues for the first time on appeal, and when a party incidentally raises an issue but does not argue it, the party has waived or abandoned his or her arguments. Below, the state argued proportionality and gender-based differences for their reasoning as on that level. They did not argue or raise the issue of whether Luis possessed the required self-defense mental state of honestly believing the use of force was necessary, nor did they raise the issue of whether Luis acted as the initial aggressor or mutual combatant. In fact, both parties below agreed that there is not a factual dispute whether Sierra was the initial aggressor, which can be seen in the record of the trial of the transcript on page 43. The state therefore waived their opportunity to raise such disputes for the first time on appeal, and the court addressing them today would not serve the ends of justice. While society does have an interest in giving the prosecution one complete opportunity to convict those who have violated its laws, a dismissal based on self-defense immunity in this case does not require reweighing the facts and coming to the conclusion that it would serve the ends of justice. The state was given a full and complete opportunity to present evidence sufficient to meet its burden. The state carried the burden below, and it failed to meet that probable cause burden. Giving the state a second bite at the proverbial apple because it failed to meet its burden below would not serve the ends of justice. And so for the foregoing reasons, because Mr. Luis Nava Ramirez subjectively believed that his use of force was necessary, and that belief is supported by facts with substantial competent evidence, and because it was objectively reasonable for him to act with such force, and that is also supported by facts found with substantial competent evidence, we respectfully ask this court to uphold the district court's decision below. And unless your honors have further questions,
Thank you, counsel.
Thank you.
As I said before, we will penalize no attorney for not using them. I do need your first name.
any
Thank you. You've got your 4 minutes, counsel.
Thank you, Judge. So I first want to touch on the, I guess, the point that we're allegedly asking this court to reweigh evidence, because we're not. We're just asking this court to consider the evidence in the totality, which is something that we believe that the district court did not do, and why it came to the results that it did is because it didn't apply all of the facts. It didn't apply the totality of the facts and circumstances here to the legal basis, and that's why it came to this erroneous conclusion that
You're saying that the court is too narrow in its vision, looked only for punch versus slap,
correct.
and not all of the evening arguments that they had and all of the wall punching and mirror punching
That's correct.
and all
Judge.
of that.
Effectively, the state's point is that the district court omitted this key context about this entire incident as a whole and just effectively just took a narrow view and saw, well, she hit him first and therefore he's immune to prosecution for that subsequent punch. And that's the issue. I also want to point out the preservation argument. Effectively, Ms. Calcagno got up here and said that we didn't preserve these specific arguments as to subjective intent. But at the same time, it's not the state's burden at the district court level to negate any sort of claims because, as the court's aware, our immunity statutes have been construed as a true immunity rather than affirmative defense. So it's not the state's burden to negate any sort of claims down below with any sort of specificity. Instead, it's the state's burden to establish by probable cause that he's not entitled to immunity. And effectively, that's what the state did. And again, we circle back to the snapshot that the district court took that the state believes is too narrow. And that's effectively why we believe this is still preserved, regardless of not arguing any specific prong of this analysis with any specificity down below. That wasn't our burden. We don't have to negate a claim of immunity. We essentially just have to establish probable cause that it doesn't apply.
Probable cause that immunity doesn't apply.
Correct. But when
You're saying that you can raise new issues or new subparts on appeal to justify that immunity or lack of immunity?
No, what I'm saying is that the entire analysis went into subjective and objective reasonableness of this use of force. And that's what the state presented, is that it was not subjectively or objectively reasonable. And obviously for the subjective prong, the state's kind of limited in what it can do. We obviously can't call a defendant to testify. So essentially we ask for the court to draw inferences based on the surrounding circumstances. And that's what essentially, again, the district court did not do.
What relief are you asking for?
Yes, Judge, we're effectively asking for the court, well, that's a little bit more of a complicated question.
Yes,
So
indeed, I know.
effectively, all the facts are here. So the state's position today is that the court can effectively determine, and the facts are not the facts are not disputed. So effectively, the court can determine whether or not probable cause.
Counsel, you're asking us to substitute our judgment for the district courts. You're not only asking us to reverse, you're asking us to find that he is not entitled to immunity. Is that not what you're asking?
No, not necessarily. We're asking you to find that the court erred in not considering the totality of the context here,
So you're asking
And
for another hearing?
erred, and therefore erred in finding that there was no probable, or that there was no probable cause that immunity did not apply. Sorry, there's a lot of negatives in there
Yeah.
under our case.
Dealing with negatives is tricky.
Yeah. Effectively, we're asking the court to find that the district court erred. Whether remand takes form of remand for a new immunity hearing, or whether the court just says probable cause, or the district court erred in finding no probable cause. I think either one can be done here. But thank you, Your Honors.
I think, let me get that done.
Still wanting to talk to you.
Yeah. Thank you, counsel. We'll take that under advisement. Next matter is 126350.
Well, I don't need more. I just,
State versus Brian Beck.
you're double hitting today too, aren't you?
I guess it's just that kind of a day, Your Honor.
Right.
But it's always a pleasure to be in front of this court, and certainly appreciate the opportunity.
Well, likewise, good to see you.
Thank you, Your Honor. May it please the court, Brian Beck appears through counsel Casper Shire, Kansas Appellate Defender. Could I get 3 minutes for rebuttal, please, Your Honor?
You've got it, your usual 3.
I typically go for 3.
You may proceed.
Driving east on I-70 through Geary County, Brian Beck was pulled off the highway over a wholly unremarkable Illinois license plate within a wholly unremarkable license plate frame. The officer who stopped Brian said that the plate was illegible, but that same officer called in the plate as an Illinois tag before he left his patrol car. This traffic stop case should have been over before it started. Furthermore, Brian's trial, at Brian's trial, the district court gave a permissive inference instruction that our Supreme Court has condemned, and the trial judge allowed a law enforcement witness to provide wild speculation testimony based on faulty math about how long a particular supply of drugs might last an individual user. In a trial that was primarily about whether Brian had the intent to distribute, that denied him a fair trial. And for all of those reasons, we are asking this court to reverse Brian's drug convictions. I'd like to start with the suppression issue. And our primary issue with the way the district court handled this was that they morphed the standard for displaying a license plate from making sure that plate is clearly legible to making sure that plate is clearly legible by an officer at a safe following distance. That's a very different standard. And it's one that's not in the statute. The officer at a safe following distance language is simply not in the statute. It's borrowed from federal courts in cases that go back a good many years, but it still comes from the federal courts and not from the Kansas courts. And our key argument here is it's this court and of course the Kansas Supreme Court that decide what Kansas law is and not the federal courts in this situation. Applying that different standard, an incorrect standard, had an outsized impact on this case. First of all, we had uncontested testimony that this license plate was visible, was legible from the squad car when the officer called it in. So it was not a question of legibility, it was a question of whether it was legible at the distance the district court thought was appropriate. And on top of that, of course, this court has the photos, which I think.
So was it legible driving down the highway or was it legible with both cars parked?
It was legible with both cars parked. But there are a number of problems with saying, well, the standard needs to be legible while you're driving down the highway behind Brian. The first one is purely pragmatic. When we're talking about safe following distance on the highway, we're talking at something around 300 feet. That is a full football field.
Doesn't that depend on how you define legible? Because isn't it true that the license plate cover, the bracket covered the word, the state name? And so the testimony of the officer was that he could make out what the name was, but doesn't that depend on how you define legible or clearly visible, which is also in the statute?
Sure, clearly legible is the standard, Your Honor, and I think that's a fact question, right? Here we have a case where the top half of the word Illinois, the letters in the word Illinois were covered, but the officer was ultimately able to read the word and call it in. I don't doubt that, the word Illinois was not legible at 100 yards as the officer is following Brian down the highway, as the case may be. And I think that's really the core problem here, is that the district court is applying the wrong standard.
Let's go back to the words of the statute. However, the statute requires both clearly visible and clearly legible, correct?
That is correct. The statute, in fact, requires two things as I read it. There are two shall be's in the statute. The first one is that the plate shall be fastened in a place and position to be clearly visible. I don't think that's an issue in this case. Also, it shall be maintained free from foreign materials and in a condition to be clearly legible. And I think that's what we're talking about. And when you morph that standard from clearly legible to clearly legible at distance X, depending on how fast you're going, that's where we've created a problem with the district court's rule.
And then you took it another step and you said that this was only a federal court decision, but we have a Court of Appeals decision, State v. Moss, where they
Yes.
adopted the federal court decision, correct?
They did, and that's an unpublished Court of Appeals decision. And it's wrong. It's wrongly decided, is our position. And it does rely exclusively on those federal cases. And again, those federal cases are what they are, but federal judges are not the ultimate arbiters of what Kansas law is. And if you look at the way our Supreme Court has treated adding language to statutes, which isn't there, they have not looked on it kindly. And I'm talking about cases like Spencer Gifts and Fowler, where they've said, if it's not in the statute, we don't read it into the statute. And here it simply is not. And we're asking this court to go against Moss, which is the only case I'm aware of that has adopted the sort of the federal standard, and to say that the statute is what it is, and we don't require any more than that. I also think, and there is a constitutional flavor, I think, to this challenge, although we are not challenging the constitutionality of the statute as written, because if you take the district court's interpretation, the officer to say following distance standard, that does invite and almost guarantees, in my opinion, arbitrary enforcement. Because now whether your tag is clearly legible depends on who is following you, how good their eyesight might be, how closely they're following you, whether they're following you in Kansas City or on the highway, because obviously the following distance is going to play a major factor in whether or not you can read the tag.
Mr. Chair, I sitting here thinking that you're using two terms in the statute as if they are identical, and I question whether that is so. The first is, as I understand it, is visible, clearly visible, and then the second is clearly legible. I don't think those terms are synonymous. Clearly visible means that somebody can see it. Clearly legible means not only can you see it, but you can read it as well. So I think the second term is more specific than the first, and it makes sense in how the statute is put together. If that is the case, then was this license visible? You said it was.
Yes,
And then once it's parked, was it legible? Once they're parked, was it legible? And you said it was.
yes.
So where did the officer get it wrong?
The officer got it wrong by, the officer testified essentially that it wasn't legible at the distance he thought it should be legible at, right? Driving down the highway, I couldn't read it. I pulled him over. And once, you know, the cars are stopped and he's, I think the testimony was that he was somewhere between 20 and 40 feet behind him. I don't remember exactly, it's in there. But at that point, he could read the tag, right? And I think that's where things went off the rails. At that point, you can read the tag, you can confirm that it's legible. And we have at least one case, Diaz Ruiz, which didn't deal with a tag, but dealt with an unrestrained ladder, or at least a ladder that the officer thought was unrestrained. Pulled over the driver and said, you know, when he got there, I think he gave the ladder a tug or something along those lines and realized it was secure. But I'd like to take a look at your license and registration anyway. I think this is very comparable to that, because even if the officer at the outset doesn't feel like the tag is legible, he gets behind him, he sees that it is, but he goes ahead and initiates the traffic stop anyway. That's not how this should work. Once the officer realizes that the tag is in compliance with the statute, Brian should be on his way down the highway.
But is it in compliance that half of Illinois is covered up?
It is if the tag is legible, Your Honor.
So the person who's looking at it has to do some intuitive thinking to figure out what that says.
There are always going to be close calls with, you know, with any statute like this. This is just like, you know, my mind jumps to great bodily harm in a battery. Well, what is that? I think it's a fact question.
Still asking that question myself.
I do too. I think all lawyers who deal with this, you know, wrestle with, well, what exactly is great bodily harm? And I think here, you know, I think judges, not juries, of course, since we're talking about suppression, but I think judges are going to wrestle with, well, is this clearly legible? Is this tag clearly legible? Here, I think the answer is yes, just because the officer testified that he was able to read it and we have the pictures. But again, I think the bigger problem is the judge applied the wrong standard. Instead of looking to see, is this clearly legible? The judge is looking to see, well, is this clearly legible at a safe following distance, which is presumably like 100 yards.
I have to disagree with you. You said that his testimony was when he was following the car and on the road, he was able to read it, but I don't believe that was correct. I believe his testimony was when he was following the car, and even when he pulled alongside it, he could not see what the state name was. And it wasn't until
That's
he
right.
pulled the car over and got behind it and immediately and even walked behind the car.
That's right. And if
He
I
was
said,
able to decipher what it was, but he couldn't see the state name because half of it was covered. Would you agree with that? I mean, that's what my understanding was, and I've got testimony here in front of me that
no,
over and over.
I think I was tracking what you were saying right up until the very end, and then I apologize. I think I spoke over you a little bit.
All right. So anyway, I'm just trying to make sure that we have the facts of this case correct so that we're really deciding this case on its own facts. So here we don't have a question of whether or not there was a safe following distance or really a following distance here. He could not read the state name while he was following it in his vehicle. It was not until he pulled it over, got out of his vehicle, that he could tell which state name, or that he stopped the car, that he called it in when he was stopped behind the vehicle, that he deciphered it and said Illinois.
Yes, that is right.
Correct?
Yes, that is right.
Right. Okay. Okay, but again, regardless of that, you would agree that this statute does require both the tag to be visible and legible.
Yes,
You're disagreeing with the interpretation that the federal courts have given us that was adopted by this court, the Court of Appeals in State v. Moss.
yes.
Okay.
And I think if I understood Judge Hill's question correctly, legible is a subset of visible. A tag can't be legible without being visible. And if I'm not understanding your question right, I apologize, but that would be my argument
Yeah,
regarding.
I just don't think the terms are synonymous.
But
Something can be visible. I can see that tag, but I can't read it. Or I can read it and see it. I mean,
yes,
so it has to be a subset of,
yes, yes, I would agree, Your Honor.
very good. Your time, my ducks have left, they have flown south, so your time, you'll still have your 3 minutes.
I appreciate it, Your Honor.
And counsel,
Thank you, Your Honor. May it please the court, on behalf of the state, Assistant Solicitor General Ethan Zipsigler.
okay, thank you.
Unfortunately, I'm in the position of having listened to the panel's questions and feeling like I could probably write a better brief now than I wrote initially, because I think Your Honors bring up a good point about the term legible and its meaning, that it has to be able to be read. And I feel that that is probably where this comes down, where we talk about able to be read from a safe driving distance. Legibility is about a person's ability to determine what's on the license plate and report it. And I think
When a statute is composed with different terms, you don't assume that they're synonymous. If the legislature says in one case visible and the other case legible, I take it at fundamental construction, they're using different terms for a reason. And they mean something differently. Do you agree? So something that's visible may not be legible, but if this has to be both.
right. I think definitely in this case, it has to be both. I would be hard pressed to be categorical about that, because I feel like human beings, when they construct statutes, are not always as precise as they need to be.
Amen to that.
But I definitely feel that, yes, in many cases, you can determine that there is additional meaning when there are separate words used. And I think this is one of those cases. I think the other point we can look to is when you go and examine the constitutional questions about vagueness and the purpose and statutes, you look to its purpose. And the purpose of a license plate statute is always going to be to allow other drivers on the road to identify another vehicle on the road. It's not just police officers. I think most human beings who have driven for any amount of time have had a situation where they've wanted to identify another car on the road for various reasons, either a hit and run, or they're seeing reckless driving, and they want to make a discernible statement about what car this was. And so the idea that the license plate has to be legible is very clearly the purpose is to allow other drivers on the road, whether law enforcement or not, to be able to identify that license plate. And I don't think that the language of from a safe driving distance has to be in the statute for it to be understood. To not have for the license plate not to be able to be read from a safe driving distance is to render the entire statute completely meaningless, because if it requires if at any distance a driver could determine it as if the driver was on top of the car, well, then that's meaningless. A driver should be able to drive safely and still identify the other vehicles on the road. And I think that is a reasonable way to read the definition of legible in this statute. The remaining questions that the defense asks are essentially for this court to substitute its judgment for the district court. The district court heard the evidence, heard the officer speak, and believed the officer that the officer could not read the license plate while on the road and until he had actually stopped directly behind the car. And at that point, he could determine it was Illinois, but only after both cars were stopped, and essentially he was directly behind the defendant. This also is what distinguishes it from the case that defense cites involving a ladder. In that case, the officer was incorrect about the violation. And what the court said is, once the officer had determined that he was incorrect about the violation, that the bladder was properly secured, he couldn't detain the driver anymore. In this case, just because the officer was able to read the license plate once the officer approached didn't make it more legible. It just meant that in a situation he wouldn't have been on the road, he could read it. And I think that's the key distinction here. I don't really have anything else on this issue unless the court has questions for me.
Well, ultimately, the officer stopped him, was gonna give him a warning.
Yes, I'm sorry. I think that was the initial approach in this case.
In his inconsistent answers, the officer then asked to search the car. My understanding of the record is Mr. Beck gave consent.
Yes, he did give consent. I'm sorry, it's been a while and I'm refreshing my recollection on this, but yes, I believe that is correct.
Right. So what's your stance on the jury instruction there?
The jury instruction was an error. I mean, I'm not going to sit here and claim it wasn't. In fact, the state, this is a very rare case. Both the state and the defense objected to the use of the jury instruction. They told the district court, it is very clear that this jury instruction is not appropriate. I don't think I could come up on appeal and tell you it was appropriate now. But it's my position is that it's constitutionally harmless. The evidence in this case was completely overwhelming that the drugs in this case were in his possession and were possessed with the intent to distribute. There's really no, in my mind, question as to that issue. So we can concede error, but still argue, look, the evidence in this case was completely overwhelming, that it was nearly a kilo of methamphetamine. There was no way it was, and there was no paraphernalia for personal use in the vehicle. So there was no real conclusion that he was using this for personal use. It was purely being possessed with the intent to distribute.
What about the officer's testimony concerning personal use and the amounts?
I think the two big things here is, one, I don't think that issue is preserved for appellate review. I don't think the objection that was lodged in front of the district court was specific to the issue raised on appeal. I think they were separate questions or separate issues. I also think the officer was wrong in his math. I mean, that's clear. I'm not going to come up here and claim opposite, but a witness being incorrect is not an appellate issue under normal circumstances. That's an issue to be determined by the jury. It's to be raised by the parties below. It's one thing if a prosecutor in closing gives incorrect statements of fact. If a witness testifies incorrectly, it's the job of the defense attorney to correct it, or it's the jury gets to consider that the officer said, I know how much this is worth, and then his math clearly doesn't line up. I mean, that's the issue. It wasn't that he was incorrect about his valuation of the methamphetamine. It was, he was incorrect about his math. And that's just not an appellate issue. That's a district court issue that should have been raised below and addressed with the jury. And under normal circumstances, unless there was something more, that's not an issue for the panel to decide. That's just something that happens in trial. Witnesses testify incorrectly and we deal with it. It's only when an officer of the court tells the jury incorrect information that we would typically get involved. And there's nothing else for me. I think that's all.
Thank you, counsel. Everybody's being very brief today. We have no problem with that. I think it's the eclipse effect. So you got your 3 minutes, counsel.
I'd like to touch on just a couple of things. First on issues 2 and 3, as to the preservation of the opinion testimony. The objection was this testimony is too speculative to come in. It's our position that keeping out speculation and putting in, an opinion are two sides of the same coin. The district court was given the opportunity to make the right ruling here. Trial counsel, in fact, referenced some of the standards in the opinion testimony statute, such as, training and experience, ability to provide, to know how Brian might use. Reasons why this would just be speculation and not an admissible opinion. And our position certainly is that the trial court or the defense attorney did enough to put this issue in front of the judge.
Counsel, I hope you speak to the jury instruction issue because quite frankly, it is rare for me to read where both sides agree that the instruction shouldn't have been given.
It is unusual. And
Do you recall many cases like that?
I don't recall
You-
ever seeing a case where both sides said you shouldn't instruct on this, judge. There's case law on it, and the judge does so anyway. That said, we're at error, and at this point, the state, as the party benefiting from the error, has the burden of proving it harmless. And I don't think the state can do that here. If you look at the state's closing argument, their argument on the intent to distribute was two things. One, it was the amount that we're dealing with. And two, it was the opinion of law enforcement. But if you go back and look at the law enforcement testimony, that law enforcement opinion was based on amount. So really it boils down to one thing. This case was all about amount. And when you have an instruction that puts flashing lights around, you may infer an intent to distribute if there's this much, that has an effect on the jury, especially in a case like this where the officer is wrongly allowed to testify that this is something like a 3 to 5 decade supply of drugs, when in fact that's just bad math. And it's impossible for me to believe that did not influence the jury's decision here, Your Honor. On top of that, I'll close by saying I'll shift back to make my last comment about the suppression issue, and that is that distance has nothing to do with legibility, right? A plate that is legible, at 10 to 15 feet is still legible when I'm 10 miles away. It's just that I cannot see it anymore. And that's where the district court went wrong, is putting in where the officer is positioned, injecting where the officer is positioned into the statute. That isn't part of the statute. And so we do ask this court to reverse the drug convictions.
Thank you, counsel. We'll take the matter under advisement and issue our opinion.
Thank you, Your Honor.
Honors?
Have a good day.
Your Honor.
I'm down to my chamber.